Good morning and good afternoon, everybody. And thank you for joining us for today's seminar having to do with the validity of wills and in particular a focus on curing or rectifying documents that are altered or wills that are not fully or properly executed. This is the second webinar in our annual estate litigation series, and we have a third webinar yet within the year that I'll mention at the end of the presentation. My name is Alex Kotkas. I'm a senior litigator in Fasken's Calgary office. I've been handling estate litigation matters for many years and also advise clients on estate planning matters in conjunction with our tax practitioners, and I also provide a general counsel advice practice. Before I introduce our other speakers, please see this information slide that I've put up on your screens. There is an ability to download the handout materials. There's a question and answer box at the bottom of your screen. You can enter questions, and we'll do our best to try and respond, although we may run out of time, but we'll certainly do our best to respond if we can. And important to us is a survey so that we can improve our presentations for you. And there's also some information about technical support and closed captioning. This is a continuation as well of our CPD certification process for the lawyers that are attending in the audience. At the end of the presentation, information will be shared so that you can obtain your Ontario or Quebec certification today. For our British Columbia viewers, the Law Society of British Columbia language will be added to the chat. And so with that, it's my pleasure to introduce my colleagues. Helen Lowe is the leader of Fasken's Wills, Trusts, Estates, and Charities practice in British Columbia. She assists clients with contentious matters regarding wills, trusts, inheritances, powers of attorney, elderly and incapable family members, and also provides advice with respect to estate planning and post-death disputes or avoidance of post-death disputes. Helen has a broad experience as litigation counsel in a number of estate-related cases and has many recognitions as one of the top lawyers in this field. Similarly, David Rosenbaum is a partner in our Toronto office. He practices in the area of civil litigation and health law, but in addition has extensive experience in disputes regarding wills and trusts, including challenges to wills, dependent relief claims, breach of trust allegations, contested account passings, and trustee compensation disputes. Now on to our presentation. We are presenting today, as I've said, on will validity. We will be addressing the legal requirements primarily in British Columbia, Alberta, and Ontario, although we will speak to the law briefly in other provinces as well. Now, in addition to sort of surveying the law in this area, what we'll be addressing specifically is the ability to cure a document that has not been executed strictly in compliance with the wills legislation. Each province has its own set of rules. There's not uniformity across the country on this topic. And the question arises as to why the courts would, or why we would have laws allowing the curing or validation of a failed effort to comply with the strict rules. And the answer is that, the law is designed to, the law regarding wills and the execution of them is designed to protect testators and prevent others from taking advantage of them, but also protect the estate and the assets that have been built up by the testator. The intention is to prevent fraud or undue influence. And so to do that, the law across the country in various ways provides a sense of formality or ritual to the execution of wills that is designed to bring home to the testator the fact that they are doing something that has importance, that they have to make this more of an occasion than something casual, and also to make an effort to avoid those who might avoid the efforts of those who might attempt to forge or alter a will to benefit themselves in an improper manner. But occasionally, of course, we have people who make alterations to wills or attempt to make a will that is not in compliance. And judges over many years have seen this happen. They've been unable to enforce those wills because they didn't meet the formal requirements. And so the law has evolved to allow for, in certain circumstances, the curing or validation of those failed attempts. We'll be addressing that today, as well as what types of records can be cured, whether they have to be typewritten or handwritten, or whether they could be electronic documents, videos, or even audio recordings. And with that, I'll pass the torch for the moment to my colleague, David.
Thank you very much, Alex, and good afternoon to everyone, or good morning, as the case may be. Ontario is a bit late to this party. It was only in 2022 that the law was changed in Ontario to allow what had been permitted in other provinces for many more years. With the introduction of Section 21.1 of our Succession Law Reform Act, which provides that if the Superior Court is satisfied that a document or writing, and I emphasize those words, that was not properly executed or made under the Act, in other words, was not formally signed by the testator, witnessed by two witnesses, and all of the other formal requirements. But if the court is satisfied that that document or writing sets out the testamentary intentions of a deceased or an intention of a deceased to revoke, alter, or revive a will, the court may, it's discretionary on application, order effectively to validate that document or writing as if it was as fully effective as if it had been executed in accordance with the Act. That is subject to our Electronic Commerce Act. What does that mean? I'll come to that in a minute, but subsection 1, the section I just read to you, only applies if the deceased died on or after January the 1st of 2022. So it was not made retroactive. The Electronic Commerce Act, that is a statute in Ontario that generally states that a legal requirement that information or a document be in writing is satisfied if that information or document is in electronic form, if it's accessible to be usable for subsequent reference. However, the Act does not apply to wills and codicils or trusts created by codicils. In other words, an electronic document will not be validated, at least that's what the Act says. But having said that, as Justice Myers said in this case of White and White, which I'll speak about a little bit more later, no one knows yet with certainty whether there are any limits on the types of documents that might be recognized as wills or what limits may apply. So as I'm sure you can appreciate, it's only been less than 3 years since this statute, this section was brought in. And there has not been a lot of litigation about it. It has not gone up to the Court of Appeal yet. I will address some of the cases a little bit later, but suffice it to say that perhaps some creative lawyering will validate some documents. That remains to be seen. And I'm going to turn matters now over to Helen to speak to British Columbia.
Thank you, David. British Columbia has had a longer history than Ontario with this similar provision, and that in BC is Section 58 of the Wills, Estates and Succession Act. Section 58 came into force in 2014, so we've had just over 10 years of experience with this provision. And I'm not going to go through it other than to say it effectively does what David described with respect to the Ontario jurisdiction, permitting for fixing effectively of documents that one would call as a will or a codicil, like a change to a will or a revocation to a will. So the BC section is fairly standard when I looked at what was contained in other provinces in terms of what it was trying to achieve. So they all are trying to give the court some ability to fix something that doesn't otherwise comply. And British Columbia did not have any such legislation until 10 years ago. The thinking had always been that the will is such an important document, as David mentioned, with respect to the Commerce Act, the E-Commerce Act not applying to wills and trusts. We considered that the making of our decision with respect to what we're going to do with our assets so sacrosanct that they have to be in compliance with very strict requirements for validity. For example, in British Columbia, the testator, the person making the will, needs to sign and have that signature witnessed in the presence of two separate witnesses who could be together or separate, but there have been traditionally and for hundreds of years very strict requirements. And so the legislation is now allowing effectively for that to be relaxed in certain circumstances. So what type of documents can be cured? In the British Columbia legislation, they use the word record. They don't use the word just will. They don't use the word document. I think that record is a broader term, and it's defined as data. And now, data includes so much, but data that is recorded or stored electronically, and data that can be read by a person, and is capable of reproduction in visible form. Now, I personally think that something that can be read and something that's capable of being reproduced in a visible form are not identical. Yet, under the legislation, it's an and as between those, so it has to be both. And that will be interesting in terms of how the courts deal with certain documents that come before it in the future. So what it does is give great breadth to the possibility of things being not really what we traditionally would consider to be a will, maybe a letter, maybe a diary, maybe some other person's document, maybe some electronic communications. So that is something that we will look at as we go through our presentation. Now, I'm going to pass it to Alex to talk about Alberta.
Very good. Thank you, Helen. In Alberta, we have three sections that are relevant to this topic, 37, 38, and 39 in our Wills and Succession Act. To begin, with Section 37, the court can validate a non-compliant will, so a will that doesn't meet all the technical requirements can be validated. As you'll see, Alberta uses the word writing. The will must be in writing, and it indicates that if the writing is not made in accordance with sections 15, 16, or 17, and if the other requirements are met, then the will can be validated. What is not included there is Section 14 of our Act, which is the section that indicates that a will must be signed. And so the outcome of that is that a will that is not signed by the testator cannot be validated. Alberta has made the decision, unlike some other provinces, that a signature is absolutely a mandatory aspect of any will. And what this does, with the consequence of that, is that you cannot have, for example, a videotaped will. That would not be valid currently in Alberta. An audio tape will would not be valid. And currently an electronic will would be questionable because it has to be signed. And the question of whether an electronic signature, as we use often in documents in the practice of law these days, whether that would be effective is up in the air. Now, the Law Reform Institute in Alberta is considering and has issued a report with respect to electronic wills, and recommended that there be some mechanisms to allow for those to be validated, but that's not yet been taken up by the provincial government. So currently we don't have that capability. Section 38 addresses alterations to a will. So you have an existing will that is self-valid, but there has been alterations to the will. And in this section, it allows the court in certain circumstances to validate those alterations, even when the alteration hasn't been done in compliance with the technical requirements set out in the Act. The court has to be satisfied on clear and convincing evidence that the alterations reflect the testamentary intent of the testator. And the interesting thing about Section 38 is that it does not require that there be any additional signature or initials. So unlike the will itself, an alteration doesn't have that requirement. And the case law that's been decided thus far, relates typically to alterations that are in the testator's handwriting, and there's solid evidence that the testator made the alterations, spoke to others about them, and that they were in his or her handwriting. And so there is a confidence level there that the alterations are what was intended by the testator, and those have been validated in the Alberta case law thus far. The final section in Alberta has to do with rectification, and this is a broad section allowing the court to add or delete characters, words, or provisions in the will. And this has arisen in the case of, for example, lawyers or paralegals omitting to include or failing to include certain aspects or sentences in the will that were meant to be included or were perhaps in previous drafts, that kind of thing. But it is you are incapable in this section of addressing the problem when there is no signature, unless it is clear that the testator did intend to sign and there was a mistake or inadvertence by the testator and no signature was applied. So still signature very important in Alberta. And moving on to the next slide, just to summarize, we have a signature requirement in Alberta. Alterations to otherwise valid wills can be cured without a signature, and we haven't yet wrestled with electronic signatures. In the rest of Canada, all of the other provinces and territories have similar curative legislation, with the exceptions of Nunavut and Newfoundland and Labrador. In Quebec, we have Article 714 there, the civil code that allows the court to probate a will despite defects of form. And I will now hand the torch over again to Helen.
Great, thanks, Alex. I am going to set out for you how the BC courts approach an application where the determination of validity is at issue. Because I think that from my survey of some of the cases in the other jurisdictions, the courts look at some or all of these same factors. In BC, our provision that I mentioned earlier hasn't actually been decided by the Court of Appeal. And as you know, that's probably as far as it can ever go in any province on a provincial issue. And the Court of Appeal has made it fairly straightforward. It can be fixed if it's a final and fixed intention of the testator. That's what the courts have to be satisfied with. And in a recent case, one of our trial judges went through the factors that would be relevant to determining if there's a final and fixed intention. So that even if the document doesn't otherwise comply, and in British Columbia, we don't need substantial compliance. So unlike what Alex said about Alberta, it is not necessary to have a signature. It's not necessary to have a witness or be substantially close to the legal requirements for validity. And so when you eliminate any need for any particular rule, it makes matters fairly discretionary and it makes the facts really count. In a recent case, the court went through a number of these factors, and they are interesting. The court will look at who made this document or the record that's being put before the court. Was it the deceased? Was it the deceased in his or her own hand? Or was this document created by somebody else? And obviously, the degree of connection to the deceased would favor a court finding a more fixed intention. The courts have looked at where this document has been found. Was it located in a place that might be where a person would typically keep an important document like a will? So if it's found in a safety deposit box, that might be more convincing than obviously something found in a trash can. The courts also look at if there has been any elements of compliance with the actual rules. So as I said, you don't need a signature. But if you do have a signature, that would be obviously more compelling. Also, what does that record look like? Does the document say the word will on the top of it? If it does, it's more likely that it is intended to be a will. And what does the document contain inside of it? Does it purport to dispose of assets similar to a will? And how does it do it? In a fair, rational way, or in something that is so odd and unusual that one would say, well, I don't feel comfortable in enforcing it. And so it's a factual test. The courts look at everything in the totality, including other facts and evidence that either give more credence to this document being a will or not. So for Thursday morning fun, I am going to let you know that we're going to review a few cases and we're going to have an interactive session. We have put into the link that you need to click on your webinar, a polling link. And that will allow you, when I review a case and ask you what you think, did the court cure it or did the court not, that you can submit your answer. And as I understand it, what will happen is we'll get immediate results. So let's practice. So here's the test question. If you click on your link, and you will see the practice question. And if you click onto your answer, let's see how long it takes before the results come up. I'm told that it's very easy, but I haven't actually done it myself. I've only been at the other end of giving the question, but not answering it. So let's hope it does work. If it doesn't, I'm just going to make up the answers. It's taking longer than the automatic session that I understand it will. But after I review a number of cases and after David reviews a number of cases in our respective jurisdictions, we are going to we're going to ask you, and then we're going to review the outcome, and we're going to maybe tell you some of the facts why we think the court reached the decision it did. Now, I am uncertain whether none of you are participating because this is not a fun interactive session, or if we're having a bit of technical difficulties. So I am unclear how that question is going to be answered. In any event, I think I'm going to go on to the next slide because I am uncertain whether or not this is working. All right, the first case that I'm going to review is called McGavin, and it was involving a woman who was living in a number of senior homes. So she was out of her house and she had met with her lawyer who had set out who had received her instructions, and then he went and sent her a couple of letters respecting what he would do with the will, how he would go and go about drafting it. He did not send her a draft. These are effectively, you met with me, this is what you told me, this is what I would do. And these two letters she had kept at the time of her death. She did not make a will that was compliant. And these letters were found in a special box that she was holding with all of her important things as she moved from care home to care home. And on one of them, she actually had a handwritten note. And that note, because she didn't have any other will, so it wasn't as though she had an existing will, that note was brought before the court. And the question was, could it or could it not be cured? Now, I'm going to try to ask the audience to do the poll again to see if it will work. And I am not at all worried about breaking the fifth plane or whatever it's called. If our tech support want to come on and tell us if this is not going to be a feature of our presentation today, I would appreciate it, and then I will carry on.
So it looks like that the responses are being logged, but they're not displaying in the presentation.
Okay. May I ask Alex that, or Tech Alex, that you just give us the results orally?
I unfortunately can't see the results. It would have to be someone from the Fasken side that would be able to see them.
Well, I'm going to have to say if it's from the Fasken side, it's not going to be Alex Kotkas, David Rosenbaum, or myself. So I think and I think that we don't have support from our firm. So I'm going to make up the answer. I'm going to say that most of you think that this is a will that cannot be rectified because it has no signature on it. It is not even a draft. It's just some instructions. Well, you would be wrong if you so voted. In McGavin, the court found that it was a will and found that the lawyer's letters enough. The letter was signed by the lawyer, but it wasn't signed by the will maker. And there's nothing on the papers when she, where she said, Yahoo, that's exactly correct, or she made a tick mark or anything of that nature. So the point of it is if that can be cured, can anything be cured? And one thing when I used to teach this course to students at the law school, I said, it's really important to know about all of the facts. In this case, if the court didn't cure that letter from the lawyer to be a will, she would have died intestate without a will. And everybody knew, all of the evidence was that that was entirely against her wishes. All right, the next case I'm going to move on to is Hupshi. And Hupshi is a case that is more what we're going to find in the future, because people don't write notes anymore except for, McGavin. Most people are on their computers. So that we can, make notes to ourselves, give emails to our lawyers, etc. And in this case, he was found with a note inside his computer. It said, "Get a will made out at some point. 5-way asset split for remaining brother and sisters. Greg, Annette, or Trevor as executor." And so he had 5 foster siblings. This is a note that he did. Even though he was telling himself, get a will made, he never got a will made. This was all that there was. So if he died without this note in the computer being proved, then it means that his estate would go intestate. I would like to ask you, do you think it's a will or not? But I have been told that the only thing that is visible on your screen is it Wednesday? So I am very sorry about this. The only thing that's certain in the world is computer glitching. But I'm just going to make it up. And I'm going to ask David. David, I'm going to ask you. In Hupshi, do you think it was a will or not a will?
Well, given, as I understand, after being put on the spot, Helen, that
that's what our audience would be.
in British Columbia, the provision in Ontario that makes it clear that only a writing can be validated and not an electronic document, I would say that it would be validated, because in British Columbia, you can validate an electronic note.
Such a lawyerly answer. And you know what? He is right. David is right. I was actually quite surprised about that entry. It's not signed. There wasn't no evidence about who could get on that computer, but obviously the court found that note to be sufficient. And it says, "To my siblings." The court decided that was an equal division. And again, I feel that if an intestacy had resulted, that is, he died without a will, it was clear that the evidence was it went overseas to people that he had no contact with, that he had no obligation to, and he really wanted to benefit his foster siblings. So sometimes hard facts also make very interesting law. All right. I'm going to go on to the next case, which is Morley. And Morley was actually quite a sad situation. I was counsel on this case. And this is a case where the deceased had videotaped himself just prior to committing suicide. And the suicide was not on videotape, but he videotaped the surroundings as to where it would be committed and then turned off the video. But just prior to that, there is a video of him signing a note, and he read it out on the video. He says, "My name is Owen Morley." This is public record, so I've used their names. "My name is Owen Morley. I have taken my life on my own accord. Please transfer all assets to my sister, Christy Lewis." The deceased died in Africa. This was an email of the video that was on a delay sent to his sister in Canada. Because we seem not to have the functionality for the polling, Alex, you are now the person up to answer. Do you think the court made this videotape a will or not a will?
Well, it certainly seems like this would meet the test of being a very solemn occasion. He'd obviously made up his mind to do this. And so I'm going to say, I'm going to guess that in this situation, the court authorized it as a will.
All right. Well, the answer is it is a will. And this is always, I think I'm sorry, I don't know why the slide is moving, so I'm just going to go back. It's a will. So in this case, it was kind of interesting. The South African police took the note. We were never able to produce the note to the court because it was part of, their country's system. The video recording, the court said, it actually had to be presented to court, and we had to pass up a laptop to the judge. And that was the only way it could be shown, was through the video recording. And obviously his demeanor, what he was saying, made it clear that there was a final and fixed intention. And the court found that that document, in fact, was a will that appointed his sister as the executor, and also that she was the sole beneficiary of his estate by what he had written. All right, I'm going on to the Godfrey case, and this is a case where a notary had prepared a draft will. After meeting with the client and getting his instructions, the will was drafted. And at the instructions of his client, it was to be sent to his client's friend's email. And I think in part she didn't have an email, or the friend was also a beneficiary under the document. And after receiving it, the friend conveyed some comments on the draft to the notary public by telephone. So there wasn't any further writing. And then the deceased died. There wasn't any further contact with the notary by either the deceased or the friend. So no one spoke to the notary again after the telephone call. Now, back to you, David. Will or not a will?
Well, I would say no, because there's no evidence that at least from the description you've got there, there's no evidence that the deceased ever saw the document. So it would be very difficult for a judge to determine that it reflected the final testamentary intentions of the deceased if he never saw it.
I think that you've hit that fact, the most important fact in that case, because the court said, no, we cannot prove that as a will. And the first point is that they didn't know that the deceased ever saw it. So even though the notary presumably properly recorded the instructions into the draft, there wasn't any evidence that the deceased approved it in any way. It wasn't even sent directly to the deceased. And there wasn't this was a case where maybe there wasn't good evidence being put forward to the court when you're trying to prove a will. And it's a good lesson. Give the court all of the facts, because all of the facts can make a difference. There was no evidence about where the draft was found. Was it only with the friend, or was it actually in the deceased safe? We don't know that. Another important fact was that the court said, well, the deceased had previously made a handwritten will. And here he had a draft, but he never put any markings on it. He didn't sign it. And he would have presumably known that that would have been an important factor. And another thing, which I didn't put in the facts, but that would inform you to get the right answer, is that there was an 18 period between the time when he went to see the lawyer, the notary, to get the draft, and when he died. So what happened in that 18-month period? Why didn't he go and get his will finalized? Is it more reflective that he was ill and couldn't get there? Or was it more reflective that he wasn't certain that that's what he wanted to do? And finally, I'm sure that you've had enough of my fake polling. I'm going to do the Cooper case because it just came down this year in BC. And in the Cooper case, the deceased made a will after he got a divorce. Now, we all tell our clients, get a new will, when radical circumstances change, like a divorce. And there was a draft made for him by his lawyer. It contained the usual, I revoked my earlier wills. It named certain beneficiaries, but most notably, it deleted from the list his former spouse's children. And of course, that is something which, probably you would do. Once you don't want your spouse, you probably don't want her children to have any benefits. But the will had blank spaces all over the place, like, who's to get the shares? And then the lawyer left blanks for the client to complete. And those were not completed. The deceased didn't sign this document. There wasn't any writing from the deceased on that draft. So, Alex, you're up again. Will or not a will? I think you're getting the harder cases.
Yeah, I am. Yeah, no, absolutely. I am going to take a guess that this is, given the pattern in British Columbia, I'm going to say it was a valid will.
Okay, well, I'm going to say you're partially right and you're partially wrong. So what the court found was that the revocation clause, which revoked his prior will that left stuff for his spouse and for his spouse's children, I should say former, was valid. But the rest of the document, the court could not find to have the final and fixed intention to be dispositive of a will. And that makes sense, right? Because there's all these blanks. How's the court going to say who's going to get what of the assets and in what proportion? So the Cooper case is very interesting in my view. It's an example of the court applying quite a surgical approach to deciding what in a document might be a will or a revocation or a codicil to a will. What elements are fixed and final and should be enforced, and what things cannot be. And so if this kind of approach is taken in the other jurisdictions, because all these cases are often cited in other provinces, it will make for a very interesting way of how the curative provision will be interpreted and applied in cases. So you've had enough of me and BC cases, and I'm going to now ask David to move on to Ontario.
Thanks very much, Helen. Whoops, went one too far. So as I mentioned, there has not been a lot of case law, given that the curative section has only been enforced since January of 2022. So the jurisprudence is certainly nowhere near as advanced as it is in British Columbia. The test was set out I've just chosen one of these cases. Voiska and Ostrowski from last year. Is the document being propounded authentic? Does the document contain a deliberate or fixed and final expression of intention as to the disposal of the deceased property on death? And the onus of proof on the balance of probabilities is on the propounder. In another case, Salmon and Rombo, the court added, just because we're dealing with Section 21.1 doesn't mean, and that gives the court the power to validate a document that was not executed in accordance with the formalities, doesn't mean that we throw out all of the other issues that need to be considered when a court is deciding whether to probate a will. So the onus is on the applicant to prove testamentary capacity. Also, the onus is on the applicant because of the circumstances to prove that the document was not induced by undue influence or fraud, and that any suspicious circumstances have been resolved. In the case of a formally executed will, those onuses are not exactly the same, and that the deceased knew and approved of the content. And as the court says, Section 21.1 will not operate to mitigate a testamentary document's formal deficiencies unless the court is satisfied first that the deceased knew and approved of the contents of the document presented for probate. Another case called Campbell, whoops, went one too far, sorry. So what happened in this case was that the deceased's will was revoked by operation of law when he got married. And he subsequently wrote 2 handwritten notes that he signed and stapled to the inside cover of the will, which the court found to be valid holograph codicils. His son, the applicant, asked the court to order, under the curative provision, that the holographs were valid and fully effective to revive the will. The court declined to do that. It relied instead on another provision of the statute that says that a revoked will is revived by a codicil that shows the deceased person's intention to give effect to the revoked will, but that the statute, the curative provision, cannot be interpreted to read into a document or writing an intention to revoke, alter, or revive a will. So the intention has to be proven. It can't be read in. And that led the court to make the comment that is quoted on this slide, that the section confers on the court jurisdiction to deem as valid documents or writings, again, documents or writings that fail to strictly comply with the applicable requirements of the statute, but that nevertheless set out a deceased person's testamentary intentions or intention to revoke, alter, or revive the will. It does not give the court license to read into these documents or writings intentions that are not already set out in them, or that are not clearly inferable from admissible extrinsic evidence. And the court went on to say that a testator's intention cannot be created out of whole cloth, which is what the court said the son was effectively suggesting using the curative provision in order to do. So what I've done now, as did Helen, is I set out, I've got 4 cases here that I was hoping we could poll the audience on. I'm told, by the way, and I thank everybody, that it appears that folks are in fact voting, but somehow the polling is not communicating with PowerPoint, so we're not getting the results. But keep on polling. At some point after the presentation, we'll get the results and we'll see how well you've done. Very sorry for this technical glitch. So the first case I want to talk about is the Cruz case. And in this case, the deceased drafted his own will, and the court said it was clearly drafted as a will, and he gave it to his chosen executor in a sealed envelope. The deceased knew it needed to be witnessed, and he put a note in the envelope asking the executor to get it witnessed. Now, of course, it was a bit late since he'd already signed it and put it in a sealed envelope, but he obviously didn't understand what witnessing was all about. And then, of course, the deceased passed away, and so the executor came to court and tried to have the will probated. So in the absence of live results, I'm going to ask, I'll start with Alex. Was this will given to the executor in a sealed envelope valid or not?
I'm a little queasy about the fact that it was in a sealed envelope, so I'm going to say not valid.
Okay, well, in fact, Justice Myers wrote that, just advance the slide, that it was valid. I am satisfied, he said, that this document records a deliberate or fixed and final expression of intention as to the disposal of the deceased property on death. That's all that it does. It purports to be a will. It is signed in the deceased's hand. The deceased just blew the formalities fixing this type of mistake is precisely what Section 21.1 seems to be for. So His Honor probated the will. The next one, the Grattan estate. So here, the deceased instructed a lawyer to prepare a will, leaving everything to her brother. The lawyer delivered a draft copy of the will to the deceased. She reviewed it, she made minor corrections, and she emailed it back to the lawyer. She was supposed to set up an appointment with the lawyer so that she could sign the will. But before the appointment could be made, 15 days after returning the marked up draft, the deceased passed away. Helen, valid or not valid?
Oh, I'd like to be the lawyer trying to prove that will, because I think the fact that she marked it up, I think that because she gave it to the lawyer, I think because she wanted to have an appointment, I'm going to say valid.
And you are correct. The court validated the unsigned will, was satisfied it was authentic, reflected the clear, settled, and unambiguous instructions to a lawyer. The court, I think, was influenced by the fact that there were only 15 days between when the deceased gave the comments back to the lawyer and when she died. If it had been longer, it might have been harder to conclude that it reflected her full and final, fixed and final intentions. But the court found no evidence that she had changed her mind within the 15 days. And the court also looked at the differences between what was in the draft document and what was in the prior will, and was able to provide some additional reassurance that the document did reflect the intentions of the deceased by admitting evidence and considering evidence about the reasons why the deceased had made her brother her sole beneficiary, and why the nephew, was one of the beneficiaries under the prior will, had been cut out. Given that there was an estrangement. There had been an estrangement between the first will and the document that was admitted to probate. The next case, Salmon and Rombo, from this year. Here there was a notebook found in the deceased's desk after his death, which contained excerpts from the previous will that he had drafted 10 years earlier. That those excerpts had been photocopied and pasted into the notebook along with handwritten annotations, at the end of which the deceased signed it, and the date of his signature was 15 days before he died. The document reduced gifts to some family members and increased the gifts to some close friends. Alex? Valid or not valid?
I'm comforted by the signature, so I'm going to say valid.
All right. And by the way, just to be clear, signature is not required. Unlike in Alberta, the court can validate a document that hasn't been signed and that hasn't been witnessed. But you are correct. The court found it to be a valid codicil. And what it did was it revoked the residual clause in the earlier will. And the court explained why. And what I wanted to emphasize here was the extensive review of evidence. And we have results that 77% said valid and 23% said not valid. So we're able to get the results, at least of this one. Thank you very much. So very good. Those who agreed with Alex. The court gave an extensive review of the evidence. This was a very lengthy set of reasons, 38 pages, in fact. There was extensive extrinsic evidence about such matters as the deceased's familiarity with and history of executing formal wills, his physical condition, his relations with various beneficiaries, so that the court could be satisfied that the document reflected the deceased's testamentary intentions. So, for example, the court noted the fact that even though the deceased had a history of seeing lawyers and getting wills formally executed. In this particular case, it made perfect sense that he didn't, as he was suffering from heart failure. His condition was deteriorating, and he was afraid of catching COVID, which made him effectively a recluse in the last few years of his life. In the last few months of his life. And the court in this case noted that the trend is toward admitting extrinsic evidence to cure a multiplicity of ills in wills, noting that the rules governing the admission of extrinsic evidence had been increasingly relaxed and refined. The purpose is to frame the testator's point of view when he or she drafted the will. The court looks to the particular circumstances of the deceased to ascertain the plain intention behind the document. And we now come to our last case, which is White and White. And this is an interesting one. So this is from last year. So in this one, the deceased made a will in 2014. In July of 2022, the deceased spoke to his lawyer several times, her lawyer several times about making changes to the will. The deceased told her son about the changes that she intended to make and the reasons she was going to make them. The deceased then suffered a stroke. She was supposed to have a meeting. In fact, the lawyer showed up at the hospital to meet with her, but she wasn't feeling up to it. So the meeting didn't take place. The lawyer had prepared a draft will, but the deceased never saw it. Valid or not valid? And perhaps we can get the results of this one as well. Just give it a minute. I will move on, and hopefully the results will then come in. If you said it was valid, or if you said it was not valid, you would be wrong on both counts, because the reality is that the court didn't decide the point, because the case dealt with whether a court could make an order requiring the lawyer to produce a draft will to see if Section 21.1 might apply to it. The court in this case was satisfied on the evidence that there was a draft will, and also agreed to order production of the lawyer's notes. And the reason I included this case was because of the comments, and this is again Justice Myers, who's written several of the decisions concerning Section 21.1, who commented about whether e-files, in other words, electronic files or electronic notes of counsel, could be found to be a will under Section 21.1. That's for another day. And those notes, I mean, I think he was persuaded that the notes could help to establish whether the draft will was a valid will. And in fact, it was only because there was evidence that there was a written draft that he was prepared to make the order that he did. But he added that he was not to be taken in this decision to be widening the scope of applicability of the section. While he is aware of cases from Western Canada in which lawyers' notes have been held to satisfy statutes like Section 21.1, in other words, like the ones that Alex and Helen have told us about from their provinces, he remains to be convinced. The section in Ontario speaks of recognizing documents that were not properly executed or made under the statute. Whether this applies beyond wrongly executed wills or unexecuted wills remains to be seen. And with that, I turn the matter over back to Alex for our conclusion.
Thank you, David. Excellent. So the question is, what lessons can we learn from these cases? And principally, as an executor or a family member of a deceased who is attending to matters relating to the estate, there is an obligation to be independent and objective, and therefore any document that you find that may be relevant to the question of whether there was an alteration to a will or a new will drawn up must be brought forward to the court. And similarly, any potential beneficiary or an error on an intestacy, if there is no will, if the will is found to be invalid, those individuals should be notified so that they can take part in the proceedings and all of the relevant parties are before the court. The other lesson or outcome of these cases is that with the change in the law that's occurred, you may have more people with claims to an estate or the ability to assert beneficiary status than previously, because changes or documents that weren't previously considered to be wills may now be valid. And the lesson, of course, the main takeaway here is if you don't prepare your will in a way that meets the formalities, or if you make alterations to your will without, again, doing it in accordance with the necessary steps, your wishes may be met. There's a chance that the court will validate your wishes, but you will increase the legal costs and create delays and uncertainty for your loved ones because you haven't followed the formalities. And so it may require a court application, which we as lawyers always enjoy, but we don't really need you to be doing that. We're doing fine. So please come to us and get the documents done properly. And let's avoid the need for court applications validating or curing any changes you wish to make to your will. We do have we've gone over just a minute, but there was one question asked. We'll answer that quickly. It was asked by Sarah, who says, if a lawyer draws up a will for a client and it's executed properly, but the client a couple of years later then does up a document that says, when I die, I'd like Sally to have my car. So this document is not a fulsome will. It's just specific to one asset. What does that do with respect to the previous will? Well, there's a presumption that a new will revoke or is intended to revoke the prior will, even if there is no words of revocation, but that presumption can be rebutted. In this case, if the later document is only about the car and it's not an overall gift of all of the assets of the estate, I think the outcome would be that the later document would be treated as a codicil or an alteration to the will. If it's unsigned, that may still be validated in some provinces. And it would be an interesting question in Alberta because of our signature requirement, but probably valid as an alteration to the will. So that's the answer to that question. In closing, please do fill out the survey. You've got the QR code there. And thank you for attending, and thank you to my fellow speakers for their work in presenting today. As a reminder, the Ontario, Quebec, and British Columbia CPD certificates are available either in the chat or on your screen. And Fasken will be hosting the final webinar in our 2024 estate litigation series on November 27. So please mark that in your calendars and keep an eye out on your inbox, at your inbox for that invitation. Thank you again for attending, and have a great rest of your day. Thanks, everyone.